Time. I call the member for Rooston.
Thank you, Mr Assistant Speaker. I rise in support of the Tattoo Parlours Bill 2012. There have always been tattooists in New South Wales, and for many years there have been legitimate businesses of this kind operating in the state. But in recent years, the infiltration of criminal organisations, particularly associated with motorcycle gangs, have tainted the industry and in many respects taken over much of its operation, to the detriment of legitimate businesses and definitely to the detriment of the community. We've seen tattoo parlours operating as fronts for criminal activities, for providing the opportunity for money laundering and an income stream for illegal motorcycle gangs. Mr Assistant Speaker, it is time for this government to address this issue that has been creeping up on New South Wales, and not just New South Wales, but as we've heard from previous speakers, is happening interstate as well around Australia. This bill is a clear commitment by this government to deal swiftly and concisely with gang crime in New South Wales. It comes on top of the Crimes Amendment Consorting and Organised Crime Act 2012 and the Criminal Organisations Control Act 2012, previously moved through this parliament. We're tackling the issue head on and we're not shying away from hard decisions to protect the people of New South Wales. The Tattoo Parlours Bill aims to break the stranglehold that outlaw motorcycle gangs have over the tattoo industry in our state. The primary function of this bill is to introduce and regulate a licensing regime for tattoo parlours and tattooists. Under this bill, tattoo parlours, as well as tattooists working in parlours, will be required to obtain a licence that they are a fit and proper person. The licence will be issued by the Director-General based on an assessment from the Commissioner of Police as to whether the person is fit and proper and whether there would be a public interest conflict in granting a person with that licence. The bill clearly defines what areas within the tattoo industry fall under its jurisdiction. It does not include cosmetic tattooing or medical tattooing and is confined to what is defined as body art tattooing. This is defined as a tattooing procedure performed for decorative purposes. This means that practitioners in medical tattooing or cosmetic tattooing will not be required to obtain licences under this Act. It will be an offence for a tattoo parlour without an operator licence to be conducting business, and an offence to have a tattooist performing work without a tattooist licence. The penalties for failing to obtain licences will be $11,000 for corporations and $5,500 for others. In order to obtain the licence, the operator of the parlour must make a statement in relation to their close associates and consent to being fingerprinted and palm printed. These measures will obviously be deterrents to criminals becoming involved in the industry. Each application made to the Director-General will be investigated and inquiries will be made. Further, the applications will be referred to the Commissioner of Police for a determination as to whether the applicant is a fit and proper person. The licence can be granted or refused by the Director-General. If granted, the licence will remain in force for 3 years. The bill makes the critical definition of what constitutes a close associate, which licensees are required to declare in their applications. Section 4 of the bill defines close associate to include any person who holds or will hold any relevant financial interest, or will be entitled to exercise any relevant power, or will be able to exercise a significant influence over or with respect to the management or operation of that business. This is intended to capture any members of outlaw motorcycle gangs who are not officially registered as part of the business but have a significant influence over the business. This includes situations where parlours are required to pay protection money to outlaw motorcycle gangs, a disturbing trend which has emerged. While the Director-General will be required to provide reasons for why a licence application has been refused, Section 20 states that the Commissioner of Police is not required to give reasons for refusing to grant a licence if doing so would result in the disclosure of criminal intelligence or information. Further, in ensuring that tattoo parlours are adequately dealt with, there are conditions attached to the operator licence. These include the licensee permitting the financial records of the body art tattooing business to be inspected by an authorised officer, and the licensee notifying the Director-General of any changes to the particulars of the licence, such as the address or operator details. The licensee is required to conspicuously display a copy of the licence at their premises. the licensee notifying the Director-General of changes in the employment of staff members. This is a crucial condition as it ensures that even if someone is employed in a non-tattooist role, they will still need to be registered with the department. This is in place to avoid a situation where the real licensee continued to work in the parlour without formally registering their details as an operator or tattooist. This bill does provide appeal rights to applicants whose licence application has been refused, as per section 27. In addition, the bill requires the Director-General to provide reasons for the rejection of the licence. Note again that this does not apply in cases where the Commissioner of Police has reported that the person is not a fit and proper person, or that granting the licence would be contrary to the public interest. If the Commissioner of Police is satisfied that the body art tattooing is being carried out in unlicensed premises, or there's a reasonable suspicion of any serious criminal offence being committed on the premises, section 28 of the bill allows for an interim closure order. In more serious cases, a long-term closure order can be obtained from the local court if the court is satisfied of the earlier conditions. It is an offence to continue operating the business when a closure order is in force. A particularly good aspect of the bill, Mr Acting Speaker, is that the bill enables a police officer to enter at any reasonable time any licensed premises or any other premises that the police officer reasonably suspects are being used to perform body art tattooing procedures for the purpose of carrying out general drug detection using a dog, or carrying out general firearms or explosive detection using a dog. I think, Mr Assistant Speaker, this assists the police in carrying out their duty in pursuing drugs, in pursuing firearms and explosives, and in laying down the law essentially to groups who would feel that they're outside the control of the law. But this will allow police to be far more assertive and proactive in their role. Mr Assistant Speaker, this bill provides a comprehensive measure to deal with the influence of outlaw motorcycle gangs over tattoo parlours, and particularly to remove the ability of gangs using tattoo parlours as points in their turf wars. Mr Assistant Speaker, I commend the Minister for Fair Trading and the other ministers of the government involved in the preparation of this bill for taking a firm stance, taking a proactive measure to curb the activities of motorcycle gangs who wish to operate outside the law, to make it much more difficult for them to do so, and to give the police real powers to take action when the law has been broken. I commend the bill to the House.
The question is this bill be now read a second time. I call the member for Shoalhaven.